Dave Monroe and Gina. We're from the Attorney General's office.
Right.
Hey, can we talk to you?
What do you want to talk about?
This is Susan Bassey, and it's not every day that individuals working for the Attorney General's office in the state of Nevada come knocking on your door, or that they want to talk about what's going on in California's family courthouses.
I don't know what authority you think we have to investigate corruption in California, dude.
These two employees of the Attorney General's office in Nevada are serving a family court order arising out of California.
I'm out here and debate this with you, man.
And leave, because you know what? This was a felony under the Nevada revised statute that you didn't investigate for 2 years. They were abducted from here.
It started as what should have been a routine custody case in front of Las Vegas, Nevada Judge Roberta Forsberg. It turned into a multi-state jurisdictional debate between California and Nevada judges. It involved law enforcement and 2 federal lawsuits, and now it involves social media and a First Amendment attorney. And we're going to show you how we got here.
Good morning. We're on the record in case D392854.
You're watching video footage from a Las Vegas courtroom where cameras, unlike California, are allowed. Judge Roberta Forsberg is presiding over a custody dispute that now sits at the center of a federal lawsuit. The case raises serious allegations of civil rights and due process violations, which reportedly began in this courtroom after 2 unmarried parents appeared to determine whether their custody case would proceed in Nevada or California, and Judge Hayashi of Santa Clara County calls into the hearing remotely. The circumstances here bear striking similarities to the case we recently covered in Kentucky, where a judge stripped a father of custody of his newborn, even though the child's mother had relinquished custody and visitation rights 4 months earlier at the time of the child's birth.
Thank you. And I object to her taking the child. She's not seen the child for 4 months. Well, she signed something that said she didn't want to see the child, Judge. She gave the child to him. He's had the child for the last 4 months.
She's changed her mind due to the erratic behaviors.
No, that's not right.
Much like the parents in the Kentucky case, the parents at the center of this Nevada case were never married. The father was in the military when the children were born, and during his deployments, the couple agreed that the mother would move to California to be closer to her family, where her father was a wealthy Apple executive. Later, during the couple's breakup, the mother filed a parentage case in Santa Clara County. Unlike Nevada, cameras are not allowed in California courtrooms, and cases filed by unwed parents are confidential if they are filed before the year 2023. Back then, the couple hired attorneys and quickly reached a custody agreement. The agreement was also to dismiss the case and get the court's jurisdiction out of the lives of their children and their family. They followed that agreement until the mother was arrested in Lake Tahoe for a DUI. Her arrest and prosecution included child endangerment, as the children were in the car with her in Lake Tahoe when she was taken into custody. Instead of going to court, where the father could have requested full custody and put the mother on limited visitation, the parents agreed that the children would live with their father in Las Vegas, where he had no criminal record, and where the children were enrolled in school. The mother dealt with their prosecution as she faced possible jail time and rented an apartment in Las Vegas. She took the children back and forth to California during their school vacations. When the mother's criminal case concluded and she had avoided jail time, she hired high-priced attorneys in both Las Vegas and California and attempted to move the case back to California, an example of a sophisticated forum shopping, or selecting the court and judges where you think you might get more favorable legal outcomes.
Chris Alderman, bar number 13061, on behalf of the plaintiff, Michael Sternberg.
Okay. Meredith Weiner, bar number 12299, on behalf of Shelley Warnick.
This unusual hearing happened in both Nevada and California simultaneously, as the judges debated the law in their respective states, and this is what it looks like when the judges discuss jurisdiction and which court will have authority over this case and this family.
So my thought is, I don't know what your thought is, Your Honor, but my thought is, look, I don't know either. Look, by her own statement, she even registered to vote here. You have to swear that you're a resident of Clark County in order to do so. So she got an apartment, leased it for a year, is just giving it up. Our understanding is it's to be given up either this month, it would have been a year this month, so she gave it up at the end of the lease, at the end of her year, and the children have been here. So my thought is, even if the other part is true that she's flying back and forth, it would seem like Nevada, that California would be an inconvenient forum when the children, now it's all child issues, that the children have lived in Nevada for the school year. So I'm just not sure what your position is to that.
Well, my tentative inclination had been to not see jurisdiction.
Yes, Your Honor, if I may.
Your request is what, Your Honor?
No, I was not intending to seek jurisdiction. It did appear to me, from what I've seen, that the original the parties had been acting pursuant to the custody orders that had previously been made by their agreement. They had modified it for the temporarily. It didn't appear to me that mother had given up residency in California. I do understand the issue with regard, and I'd like to, with regard to registering to vote, and I'm not sure why that was done.
So I think first and foremost, I think we're forgetting a few key facts here. First of all, there was a temporary order issued in California. There was no final order. So to sit there and say that there was a final order that the parties subsequently agreed to make a temporary change to is not accurate. They went to a mediation, entered a temporary order, which got filed. There's never been an evidentiary hearing or anything in that court. Less than a year later, the parties, through counsel, stipulated to dismiss that case. The pleading was drafted. That was not filed through the fault of counsel, but the parties' intent was to dismiss that California case over 4 years ago. Okay? So then we fast forward to now. She, meaning Shelley, the party in your courtroom, the defendant here, she relinquished custody to my client after she had a DUI with the kids in the car. He didn't ask for custody of those kids. She voluntarily gave the kids up knowing that they would be in Nevada for 1 year. He's had primary physical custody of the children for 1 entire year where they've been in school. He's been open with communications. She's had visitations. And I think we need to give more credence to the fact that she did have an apartment here. She did register to vote. Now, I understand you can own property in California.
Counsel, this is Judge Hayashi. I need to point out that there was a judgment entered here in Santa Clara County on October 4th, 2012. The judgment was not only a judgment to parentage, but it also was a judgment with regard to custody and visitation. And custody, under the party's judgment, was joint legal custody as to both parents. That judgment has not ever been modified, counsel.
I think what he's saying, Your Honor, and this is Judge Forsberg, he's saying that the parties entered a stipulation to dismiss that entire action, but somebody's counsel did, I believe it was Ms. Warnick's counsel, is that correct?
I don't think, excuse me.
Did not file the dismissal. They signed it all. They both stated in my court that they did sign a dismissal request. Both parties, and I have both counselors say that's true. Ms. Warnick said they both signed a dismissal of that action. Somehow it did not get filed. That's what Mr. Sternberg's counsel is stating, Your Honor.
I understand this, but it was my understanding, and perhaps I'm wrong, but it was my understanding that the request for dismissal was made after the judgment had been entered. So under our procedures, a request for dismissal that is made after a judgment is entered does not serve to set aside the judgment. The judgment has already been entered.
Okay, and certainly that would be different in our court. So, and that was also our question, because we did not know of course, not knowing the law in California, being a Nevada judge, I don't follow all of that, but you clearly, that's different in Nevada. If they'd stipulated it to be dismissed, it would have been dismissed here in Nevada. So you're saying, Judge, that that's different. It's still in order. Your position is it's still in order because nobody dismissed it. Until the judge says it's not in order, it's still in order. Correct, Your Honor?
Unless the judge sets aside the judgment, and there would have been a procedure to set aside the judgment,
okay,
and then dismiss the action, but there was never a request to set aside the judgment or for the parties to be relieved of the effect of the judgment. So even if they had filed a request to dismiss the action, if the judgment is not set aside, the judgment still stands.
Okay, Your Honor. Then it's clear that you're requesting that jurisdiction remain in California based on the facts, and I'll certainly agree with that.
Your Honor, excuse me, I'm sorry. May I have a minute with my attorney, please?
This is not the time, sir. Your time to talk to him was previously. Your counsel is here to make the
I would like to get some
representation.
stuff on the record, please, which I believe is my right.
Your Honor, Mr. Sternberg would like a moment to add some things to his client to make a record.
Then excuse me, Judge Forsberg, because I have a 9 o'clock call.
I do too, Your Honor.
Expected in another case.
This case is typical of what we see in California's family courts where cameras are not allowed. America's family courts are true black boxes in our legal system. In these courts, 90% of litigants have to represent themselves because they either can't afford a lawyer or because they are tired of paying lawyers thousands of dollars for legal outcomes where the checks and balances exist only in theory and overpaid bullies continue to outmaneuver the Constitution. This hearing was only the beginning for this father, who was stripped of custody following the hearing for no legal reason that we can find. He has no criminal record and faced no allegations of domestic abuse. After the hearing, the father was arrested and faced years of First Amendment retaliation after he filed a disqualification statement against Judge Cindy Hendrickson, who was assigned to the case, and he was representing himself when he did. The father has not seen his children for 5 years since the Nevada courts allow the case to flip to California. He filed a federal lawsuit representing himself, and the mother, who was named in the case, hired an attorney who claimed to be a First Amendment attorney. He tried to have the case thrown out on an anti-slapp of an abuse of process claim. But last week, federal court Judge Gordon of the Nevada federal court system ruled against that First Amendment attorney and issued an order that is allowing the father to address the mother's abuse of the legal system that he alleges was in order to gain full custody of their children through legal maneuvers that are nearly impossible for a pro se or unconnected attorney to address in California's courts.
Okay. Well, here's the order, and good luck with it, okay? I'm going to email you the other copy.
Fine. Please do not come again unannounced unless you have a warrant.